It looks like New York City Council is going to make 2020 rent-free for all. Let's listen to the Councilman Yeger ask the question, can the council block the sheriff or control the sheriff in New York City?
Member Yeger, followed by Councilmember Cabrera.
And Councilmember Yeger, your clock will start when you begin your testimony.
Well, I'm not testifying. I'm a member of the council.
Oh.
How are you? Thank you. First of all, I'd like to echo Mr. Speaker. I agree with the portion of his opening statement that says that we do need rent cancellations. We do need reductions. I also believe, as Mr. McGee said, and Mike McGee's been a leader in tenant advocacy, so this is an important point from him, that has to go hand in hand with relief for landlords, particularly small landlords. I'm not worried about the very large landlords. I am worried about the small landlords. Excuse me, I have some background noise. But my question, more importantly, is to Ms. Schreiber, and since you're the only lawyer on the panel, I wanted to ask you this question with regard to Introduction 1912. My understanding, and you can correct me if I'm wrong, is that the authority of a sheriff or a marshal to execute a judgment comes from state law. And state law, particularly the CPLR, with respect to executions when a sheriff receives it, contain the word shall. Do you believe that the city council has the authority to supersede state law and to replace the word shall when a sheriff receives lawfully received and executed income execution or money judgment execution or a warrant?
So thank you very much for that question, Councilmember Yeger. We believe, with regard to city marshals specifically, that the mayor has the authority to direct city marshals to stop enforcement of judgments, and that the city council has the power to legislate here as a result.
Okay, and that the city council, notwithstanding the fact that if a judge or a clerk of the court or an officer of the court signs an execution that says at the top, the people of the state of New York to any sheriff or marshal, and gives it to a sheriff, the sheriff can put it aside because we passed a law that says so?
I think that the sheriff would not be placing the judgment aside indefinitely. It will be executed. Let's say, not could. It will be executed when the moratorium is lifted, and it would not be flying in the face of state law to say that judgment is going to be paused, for lack of a better word, for now, until such time has passed that it makes sense for the community at large for judgments to resume being enforced.
I appreciate that very much. Well, the sheriff is going to come on and testify in a little while, and I'm interested in hearing his opinion on this topic. But I appreciate all of the advocates who came today and the important work that you do, the lawyers who are on the front line, and Mike McGee, who's a legend in tenant rights and tenant defenses. And I'm a tenant too, and I can pay my rent, so I'm going to, and I will. But there are a lot of people who are suffering right now and can't. And I'm going to use the remaining clock that the sergeant has at 40 seconds to say that I do believe there are things that the city council can do to relieve the burden on the owners, in addition to the tenants, because it can't just be that tenants stop paying rent simply because we say so, and notwithstanding that they're not able to afford it. Tenants who don't pay rent and can't afford it will never be able to make that up, and that's going to leave a hole. And we have to do it. We have to do it on both ends. We have to help the tenants and freeze their rents, and we also have to help the landlords, and we can do it on taxation. We can do something to relieve the tax burden by stopping the interest payments on late payments. We can stop the interest on late payments and allow the owners to have a little bit of float so that they don't have the proverbial gun to their head on making payments at the same time that they're not receiving an income. So that's why your advocacy on this, Mike, is so important, because you're recognizing that it does come from both ends. we can't just stop it on one end. We do also have to help those people who have those 20-unit buildings before they get the other 8 20-unit buildings. And so I want to thank you all. Thank you very much, Mr. Chair, and I yield back.
Thank you. We'll now hear from Councilmember Cabrera, followed by Councilmember
Let's move
Powers.
ahead to the sheriff.
And your clock will start.
The community, the commission.
Not the
We've all
sheriff.
been touched by this crisis, my office included, with the loss of loved ones. Sheriff Public Safety Officer Serge Paul passed away last week after a brave struggle against COVID-19. He was a dedicated law enforcement officer, husband, and father, and I would be remiss if I did not publicly acknowledge his dedicated service and sacrifice. The Sheriff's Office fully appreciates what we believe is the Council's intention to provide relief to New Yorkers from debilitating seizures of property and monetary assets. However, Intro 1912, while well-intended, raises significant legal concerns for my office. The work of our office is integrally related to the work of the judicial system and governed by state law. May I take a moment to provide a quick explanation about judgment enforcement matters. A judgment is the final outcome of a court case. A judgment resolves the contested issues and terminates a lawsuit, since it is regarded as the court's official pronouncement of the law on the action that was pending before it. The judgment states who has won the case and what remedies are awarded to that prevailing party. Remedies may include monetary damages, injunctive relief, or both. Judgments are enforced by writs of execution, which can be addressed to the sheriff or in New York City to the marshal, commanding them to give plaintiff possession of land or to enforce the delivery of personal property, which was the subject of an action, or to collect the amount of the judgment, depending on the relief sought in the underlying case. As I've described, judgment and execution enforcement are mandates that come from the court. They are under the governance of the state court system and implemented through the state civil practice law and rules. Indeed, they represent the core function of the judiciary branch and the ultimate expression of its independent decision-making authority. We believe that Intro 1912 would require actions that interfere with this well-established structure. The bill assigns duties to the sheriff that presupposes the sheriff has control over the judgment and execution process. However, that is not the case. The sheriff is an officer of the court and wholly guided by the exacting statutory steps set forth in the CPLR, which preclude the sheriff's personal judgment or outside review. Courts have repeatedly held that a sheriff cannot look behind the court mandates or review them for error and can be penalized for doing so. For these reasons, it is our view that the sheriff could not comply with the directives of Intro 1912 without violating the panoply of state laws that govern the sheriff's role as the civil enforcement official of the courts. In my role as sheriff, I am not a heartless bill collector, but rather an officer of the court who has a duty to enforce the laws enacted for the protection of the lives, persons, property, and health of our citizens. I hope that my testimony today has conveyed my passion for following the law and having the office of the sheriff working productively and cooperatively for the betterment of all New Yorkers. Thank you for your time, and I will now take any questions.
Thank you. We will now open it up for questions from Speaker Johnson and the Sheriff's
Office.
1988.
Okay, so I'm gonna say, at least for myself and for a good number of my colleagues in the council, I would think it's fair to say you probably have a greater understanding of your powers and authorities than I do. I just want to focus, I think, on some of the remedies, since it's so clear to me that this law cannot be enforced, Introduction 1912. If it were to be enacted, you would not be legally allowed to follow it under any circumstances. I don't doubt for 1 second that the mayor would not fire you for not following an unlawful act of this council. I know for sure that the mayor values his oath. I know you value your oath. I value my oath as a member of the council, but I also value my oath as an officer of the court. And a sheriff is an officer of the court, an arm of the judicial system. So I want to focus on some of the remedies that can be done instead. My understanding, obviously, is that your powers come from the CPLR and from state law. But clearly, if the chief judge of the state of New York were tomorrow to issue an order directing judges in the state that they may not issue executions. Is it fair to say that you would not receive executions because judges would stop issuing them?
Yes, if the court directed us.
All right.
We would do it.
So, the obvious solutions to these problems don't come from the well-intentioned efforts here in the council, but the notion that there are places in this state that govern your activity, and you do not have the ability to decide to refuse to execute on an execution that you receive. But more to the point that you stated earlier, there are remedies should you receive an execution. Number one is there are notice provisions, correct?
Correct.
And number two is when you actually seize property, you don't immediately that day or the next morning turn it over. You actually hold it for quite a while to allow for it to fit within the confines of the sheriff, so that the debtor can actually collaterally attack the execution and the underlying judgment if necessary. Is that correct?
Correct.
So there are remedies, as we know. My concern, of course, is, as I've said, Sheriff, and you may not necessarily be aware of this, but I say this for the greater public. I have, in my time in the council, been, I believe, very protective of the authorities of the council. I believe that the council has authorities as it is stated in our charter and under state law, but it is limited. And when it is limited, we should not try to cross that line. We should respect the authority of the law. In this case, the state is the place that needs to make these instructions to you. And I would suggest to my colleagues that is the better way to go with respect to the good intentions of this law. And with that, I yield back my time. Thank you.
Thank you.
We still have to carry out, even though COVID-19 is going on, but we can take obvious safety precautions for our officers.
Thank you. And if the state moratorium lapses, are you going to rely on the courts to determine whether someone is protected by the federal moratorium?
We have to. Unfortunately, in my role as sheriff, while I have personal opinion, and like I said, my personal feeling is I think that these concepts are very good to explore. In my role as sheriff, I have to be somewhat agnostic and standoffish, neutral. I can't really weigh in on which is coercive. The court could apply a criminal contempt to me, which would jail me for 30 days, and a civil contempt, which could jail me indefinitely till I perform the act. An example was recently you had a county clerk who refused to take marriage licenses. That's a ministerial act. And if the sheriff is required to carry out a ministerial act and he refuses, he faces probably the most severe punishment available under the law for an officer. So I face both a personal liability, criminal and civil, but if I carry out the order, I am fully immunized and I have the full backing of the court to do so.
So since you're an agent of the state court, neither a federal nor a local moratorium is viable without the buy-in of the court. Is that what you're saying?
Yes. Unfortunately, the court, in the courtroom, the court's process really controls what the sheriff does. And since the sheriff has no ability to look behind the court's order, then whatever the court tells the sheriff to do, the sheriff must do. The sheriff leaves these issues for the litigation in court. That's why a lot of civil process has a notice requirement. The sheriff gives notice before he does something, and that gives the person the opportunity to go to court to make these claims. Many of these issues that you're bringing forward are claims that would be appropriately made in court, not to the sheriff.
This might be a question for HPD, but suppose in the absence of a moratorium, is there anything that the city could do, the council could do to address egregious cases of rent gouging in an attempt to exploit the COVID-19 crisis?
So I don't know that we're prepared to comment on that. I haven't heard that as a suggestion at this point, council member, but we can certainly take that back to see if there's been any discussion around that particular issue.
Like, I see my time is about to expire, so thank you for affording me the opportunity.
Thank you. Now we'll hear from Councilmember Yeger, followed by Councilmember Powers.
And your clock will start now.
Thank you you very much. Sheriff, thank you for being here. First, I just want to echo Mr. Speaker's comments. Anytime somebody in our greater family of New York City employees is taken, it's a shock not just to the greater system, but obviously to the employees who are close with that person. And your office being the small office that it is, I'm sure, I have no doubt that it's hitting you folks at the Department of Finance pretty hard, and I want to express my condolences. Sheriff, in your opening testimony and in Councilman Torres' questions, you really did allude to many of the items that I wanted to talk to you about today, and some of which I discussed with the earlier panel. But I want to get some more information a little bit, just so that we can have some clarity. So, if I may, when did you start working at the Sheriff's Office?
1988.
Okay, so I'm gonna say, at least for myself, and